clarifies that we're still waiting for some testing.
Jermaine Young, 240916. I decided to quit saying DCCR. I'm over it. It's too much. All right, sir, you Jermaine Young?
Yes, ma'am.
And Mr. Young is charged with aggravated sexual assault of a child. And Mr. Burbank?
Who aggravated sexual assault of a child. That's one of the most serious charges in Texas, carrying a potential life sentence. Notice how calm the judge stays. That's courtroom professionalism at its peak. But behind that calm tone, everyone in this room knows the gravity of what's on the table.
What is the announcement?
I think we're still waiting for some testing, Judge.
We are, Judge. I put a call in. I got a response on my DNA. That's the only thing that we had at CPS. We've received that.
Got that.
So this is the only thing that we're waiting on.
And did they give you any type of?
All through with them.
All right, let's do, we'll do, now that we've got CPS, that's the only thing we're waiting on. I'm going to do 60 days. And then hopefully we'll have some information, obviously when it gets close, if you can get back with them and see where we are. If we need to let them know of some special setting to make it move up, then we'll see if we can get that done.
Yes, ma'am.
Stay in touch with Mr. Burbank. He'll let you know when you need to be back.
Yes, ma'am.
All right, we're free to go. Yes, sir. So I wonder where,
Sorry that I borrowed some time, but I can't tie it.
it's all right, you're good. All right, are you Maverick Neal? And Mr. Neal's charged with aggravated assault with a deadly weapon in 24 DCCR 2436. And what is the announcement?
Judge, we'd reset for me to try to contact the complainant. I'm not getting any answers for written correspondence or the different phone numbers my investigators been able to locate for. But I'm not inclined to dismiss because of the seriousness of these charges, Judge. I've made a probation offer, which I believe is going to be rejected. And if that's the case, I guess we're set for trial, and I'll could double our efforts to locate her.
And you intend to go forward with or without?
I believe I can prove the case without her presence, Your Honor.
Okay, so if, sounds like there needs to be a rejection done. If there's not going to be, if he does not want to accept any plea agreement, let's get the rejection done this morning. That's on the tablet, and then I'll call you back up when I'm ready to take care of that.
Anthony Whitmire.
All right, so Mr. Neal, in cause number 242436, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, I do.
And I have here on the computer a plea bargain rejection that you've signed with Mr. Doyle. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your case, for a 5-year deferred probation.
Okay, quick legal insight. What the judge just explained is a deferred adjudication. That means if he completes probation successfully, the conviction disappears like it never happened. Sounds like a great deal, right? But here's the catch. One slip up, and he's staring at the full felony conviction. Would you take that deal or risk a jury trial?
Probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. And with that type of probation, if you successfully completed it, the case would be dismissed and you wouldn't have a felony conviction. Do you understand? So I want to make sure that you do understand everything, because it's very important that after today, if I put your case on the trial docket, I won't accept this plea agreement. All right, so if you want the plea agreement, fine. If you are not guilty and you want to have a jury decide, that's fine as well. Mr. Nichols has stated earlier today that he intends to go forward with or without the complaining witness in this case. So we've talked about that. I don't want you to think that at some later date he intends to dismiss the case or something would change unless there's new evidence that comes forward. So if you don't want to take this 5-year deferred probation, that's fine. We'll put it on the trial docket, but I want you to make sure you understand that I will not accept this agreement after today. If you change your mind later and you want to enter a plea of guilty, then you can plea open to the court or to some other plea agreement. Do you understand that? And do you want to reject that plea agreement and have your case set for trial? It's your decision.
Sorry.
I mean, go ahead. I mean, if y'all need to talk some more, but
You don't want to plead, correct? Yes, you want to plead, or no, you don't want to plead? That's what we've been talking about outside.
so you've been talking about it with Mr. Doyle.
Because I'm not understanding
What are you not understanding?
it's been 4 times, right?
I don't know about 4 times.
He's talking about the docket calls.
Okay.
The state had indicated to me that they might have, or I indicated to the state rather, that the victim didn't want to prosecute the case.
Right.
He's never been able to get a hold of the victim.
Right.
To have her tell him that. He feels like he's been up here enough that I have the authority to make the state dismiss it, and I don't.
No, correct. So Mr. Doyle is doing everything he can with trying to negotiate with the district attorney. And it is legally possible for the state to go forward with the case without the complaining witness, and that is what they intend to do, according to Mr. Nichols, correct,
Yes,
Mr.
sir.
Nichols? So with or without her, they're going to present the evidence that they do have to a jury, if you go to a jury trial, and then that jury can decide whether or not you did or didn't do what they're charging you with. So today is the day to decide if you want to go.
This is where things get intense. The defendant wants the case dismissed because the victim isn't showing up, but legally, the state doesn't need her to. They can still move forward using other evidence, like witness statements or physical proof. What do you think? Is it fair to prosecute without the victim's testimony, or does that weaken the case?
To trial and let that jury decide whether she comes or not, case isn't getting dismissed, or if you want to enter a plea of guilty to the offense for that 5-year deferred probation. So you want to have a jury decide. Then I will place your case on the trial docket. Mr. Doyle will begin preparation for trial.
Okay, do you have an idea?
They'll send you that date. We're about
Okay.
3 months or so.
Okay.
Okay? Yes, sir. Thank you. You're free to
Thank you,
go.
Your Honor.